If something happened to you tomorrow, do you know who would raise your kids? Most people think they know. They assume a family member will just step in. But unless you've named a legal guardian in your estate plan, the court will decide. Today, we're going to talk about what actually happens when no guardian is named, how the court chooses, and how you can make sure your children are cared for by the right people, not just whoever the judge decides. I'm Emilee Morris Ratcliff, and I am an estate planning attorney here in Oklahoma. I help families protect what matters most, and that starts with protecting your kids. Whenever the court has to get involved with appointing a guardian, your potential guardians will have to get a court date, attend court hearings, and provide evidence as to why they should be the guardian. That's why this topic matters. Guardianship is not about money. It's about who will make decisions for your kids and making sure that they get the care that they need. So what happens when you don't appoint a guardian? Let's break it down step by step. If you pass away or become incapacitated without naming a guardian for your children, here's what happens. First, the court takes over. A judge who does not know your family takes a guardianship case. Second, family members can come forward and seek guardianship of your children. That might sound fine, but as you can imagine, it may lead to major conflict. If no one steps up or is qualified, your children may even be placed into temporary state custody, which is foster care, until someone is appointed. The judge decides based on best interests of the child, which sounds nice, but it's fairly subjective. This could just be based on how your judge views one family member over another. Meanwhile, your kids are in limbo, different schools, different homes, and confusion, all while trying to grieve the loss of you. But this can be avoided. You can name a guardian for your children. When you name a guardian in your will or another legal document, you are telling the court, this is who I trust if I am not here to care for my children. That one decision gives the judge guidance, saves your family from fighting, and gives your children stability. And here's the thing, naming a guardian does not mean that you're predicting tragedy. It just means you're the kind of parent that plans ahead, even for things that happen that we never hope for. Here are some common questions I hear from parents. First, can I name more than one person? Yes, you can name a primary and then a backup just in case the primary person is unable or unwilling to serve as guardian. Next, can I name someone out of state? Yes, you can, but you may want to talk to an attorney about how that might affect the child's relocation or approval within the state. And then what if my family disagrees? Well, that's exactly why you want it in writing. Because if someone disagrees, a signed legal document settles arguments before they even start. So here's your next step. Don't let a judge decide who raises your kids. Sit down today and determine the person who shares your values, your parenting style, and your love for your children. If you're in Oklahoma, Morris Ratcliff Law can help you do exactly that. We'll walk you through every step, from naming a guardian to helping you protect your assets for your kids' future. Call us today at 918-609-3932 or visit us online at morrisratclifflaw.com. Your kids depend on you to protect them even when you're not there. Let's make sure that you have that covered.